Hello everyone. The topic for today's discussion is development of civil law in British India under Mofussil. And under this topic we are going to discuss the development of civil law. So my friends, I am Dr. Sharmila Guge and today the discussion will develop on the civil laws in British India under the Mofussil. Well, proceed with this, we go ahead with the objectives. The objectives of this particular module are to understand development of civil law under Mofussil and to analyze the complex interplay of personal laws and other laws in the Mofussil region. For our introduction, we go to the British era for the detailed discussion. The ongoing of the British East India Company's presence in India marked the commencement of an intricate legal system that underwent a transformative evolution of several centuries. At the core of this sophisticated system was the civil law, a fundamental component of governance that played a pivotal role in shaping the trajectory of British rule in the Indian subcontinent. The transformation of civil law was particularly pronounced in the Mofussil regions, which were geographically distinct from the more prominent presidencies and represented the diverse and decentralized nature of colonial administration. The term Mofussil originates from the Persian language, where Mafuz signifies being outside or situated in the provinces. Within the context of British colonial governance, the Mofussil regions denoted areas lying beyond the metropolitan centres, embodying a complexity reflective of the diverse culture, linguistic and social fabric of the colonial India. This geographical distinction held profound implications for various aspects of colonial rule, extending its influence to justice administration, socio-economic policies and the evolution of civil law. The Mofussil region holds a distinctive position in the historical narrative of British colonization in India, serving as a crucial chapter in this intricate tapestry. These areas become crucibles for experimentation and adaptation, standing in contrast to the more established presidencies of Bengal, Madras and Bombay. The Mofussil region presented colonial administrators with unique challenges given the intricate mosaic of local customs and practices, diverse languages and verified traditions that shaped the social cultural landscape. This diversity demanded a nuanced and a flexible approach to governance. As the British sought to extend their influence into their heterogeneous territories, the Mofussil regions emerged as a dynamic laboratories for governance experimentation, including the establishment of legal and judicial systems. Well, the distinctiveness of these areas necessitated a departure from the standardized approaches adopted in the presidencies, giving rise to a localized and adaptive form of administration. In light of the aforementioned, this exploration aims to delve into the historical development of civil laws within the Mofussil regions during the era of British colonial rule. By examining the interplay between colonial powers, dynamics and the intricate local context, this research seeks to unravel the complexities inherent in the evolution of civil law in these distinct areas. Well, the Mofussil region with the diverse tapestry and unique challenges serve as a testament to the adaptive nature of governance under the British colonialism, offering valuable insights into the broader dynamics of colonial rule in the Indian subcontinent. Well, with this we proceed to understand administration of justice under the Mofussil. Upon assuming the role of Governor of Bengal, Mr. Warren Hastings encountered a severely compromised state of justice administration. The dual government structure in place was notably defective and unsatisfactorily leading to a near collapse of the justice system. Courts had deviated from their intended role as dispensers of justice to becoming instruments of power, rendering them ineffective for protection and prone to misuse for oppressive purposes. Recognizing the failure of the dual government system, the East India Company entrusted Governor Warren Hastings with the authority to institute regulations and measures aimed at securing advantages for the company and liberating the ryots from the oppression imposed by zamindars and petty tyrants. Well, Warren Hastings initiated substantial reforms in the administration of justice, which can be analyzed in 4 stages. The first and foremost, he acknowledged the pivotal role of an impartial and systematic administration of justice in facilitating improved land revenue collection. Consequently, alterations were introduced in both civil and criminal justice, accompanied by additional provisions. Another significant development was the division of Bengal into 3 presidencies, into multiple districts to enhance administrative. So, basically the 3 presidencies, Bengal, Bombay and Madras, were divided into further districts. Furthermore, Warren Hastings appointed Impey to see the reform of the judicial system. Mr. Impey contributed to the instrumental in introducing much needed changes under the robust oversight of a powerful authority. Notably, Impey's compilation of the Civil Procedure Code marked a commendable step towards establishing a clear and stable legal framework, providing populace with a comprehensive understanding of the court procedure. To mention here, Mr. Impey was the first Chief Justice appointed at the Supreme Court established in Calcutta by the British. As a part of the reform efforts, the establishment of Mofussil Diwani Adalats in each district emerged as a significant innovation in the realm of civil justice. These courts, presided over by the collectors serving as judges, adjudicated various civil cases encompassing property disputes, inheritance matters, succession issues, caste related conflicts, marriage disputes, contractual disagreements and financial disputes. Notably, the application of Hindu law to Hindus and the laws of Quran to the Muslims in cases involving inheritance, marriage, caste and religious practices ensure contextually sensitive approach. To further enhance the judicial process, Pandits and Qazis were enlisted to assist collectors in matters concerning Hindus and Muslims, respectively, providing expert insights into applicable laws. Appeals from these district courts were directed to the Sardar Diwan Adalat in Calcutta, whereas cases exceeding Rs 500 in value were heard. This central court, with the governor as its president and with minimum of 2 council members, served as the appellate authority, consolidating and reinforcing the hierarchical structure of the justice system implemented during Warren Hastings' tenure. We move further to discuss the plan of 1774. Well, the restructuring of the judicial system in 1773, prompted by the dissolution of the collector institution based on recommendations from the Court of Directors of the East India Company in England, disrupted establishment judicial arrangement of 1772. Recognizing the imperative for a new plan, Warren Hastings formulated and introduced a comprehensive proposal on 23rd of November 1773, with its implementation taking effect in January 1774. The imperative for this restructuring was necessitated by the evolving needs of the time and inadequacies exposed by the removal of the collector institution. Moving ahead, central to this revised plan of 1774 were substantial amendments to the provisions governing appeals in civil cases. The revised plan introduced a significantly more liberal approach, allowing all cases adjudicated by the Mofussil Diwani Adalats to be subject to appeal before the provincial council, regardless of the monetary value of the subject matter in dispute. This marked a departure from the previous restriction and signified an effort to streamline the appellate process for more accessible and responsive justice system. Furthermore, the plan incorporated provisions for a second appeal, which could be pursued before the Sardar Diwani Adalat in instances where the value of the subject matter exceeded ₹1000. This two-tiered appellate structure aimed at providing a more comprehensive and layered approach to the resolution of civil cases, ensuring that matters of higher financial magnitude were subject to additional scrutiny at the appellate level. In essence, the restructuring of the judicial system in 1774 under Warren Hastings' guidance not only responded to the immediate need arising from the abolition of the collector institution, but also sought to enhance the overall efficiency, accessibility and fairness of the civil justice system in British India. Well, the liberalized provisions for appeals represented a pivotal shift towards a more inclusive and adaptable legal framework reflecting an evolving understanding of the complexities inherent in the administration of justice during this particular period. Moving ahead to discuss the Patna case and its impact. The deficiencies inherent in the 1774 judicial system became glaringly apparent in the famous Patna case, which revolved around the jurisdictional conflict between the Supreme Court and the functioning of adalats in the Mofussil areas. During this period, both the Mofussil adalats and the provincial councils enlisted the services of the qazis and maulavis for interpretation of Muslim law, a common practice at that time. Unfortunately, this practice inadvertently led to the neglect of judicial duties. In the Patna case, the unique circumstance emerged where the Maulvi and the Qazis were granted authority to both gather evidence and render decisions. This departure from established legal procedures resulted in an irregular collection of evidence, leading to provincial council to pass a judgment based on this unconventional method. Well, the Supreme Court upon review found that the provincial council had failed to adhere to the prescribed judicial procedures outlined by the Supreme Court. Consequently, the Supreme Court issued an order directing the imprisonment of those involved in the deviation from the established legal practices. However, the decisions of the Supreme Court faced substantial criticism in the British India. In the aftermath, the operations of the Mofussil Adalat grounded to a halt as officers were reluctant to engage in judicial work, fearing potential imprisonment. This reluctance significantly impacted not only the judicial proceedings in the Mofussil Adalat, but also had severe repercussions on revenue collection activities, as many revenue officers chose to resign from their positions. The Patna case thus stands as a critical example of challenges and disruptions during the introduced in the flaws of 1774 judicial system. The clash between traditional practices and emerging legal framework highlighted the need for a more coherent and enforceable set of regulations to govern judicial procedures in the Mofussil region. The repercussions, including the suspension of judicial activities and the hindrance to revenue collection, underscore the importance of a well-defined and uniformly applied legal system for the effective administration of justice and governance in colonial British India. Now, let us take a glance at the establishment of Diwani Adalats. Well, the establishment of Diwani Adalats in the Mofussil areas during the British India represents a significant chapter in the evolution of the colonial legal system. The term Diwan Adalat refers to district level courts that played a crucial role in dispensing justice in the Mofussil region. During the British colonial period in India, the need for a well-organized and accessible legal system became apparent as the administration grappled with diverse customs, languages and cultural nuances across the vast continent. The Mofussil areas, characterized by their decentralization and cultural diversity, posed unique challenges for governance and justice administration. Recognizing these challenges, the British authorities sought to establish localized legal framework to address the specific needs of Mofussil regions. Well, the establishment of Diwan-e-Adalat was motivated by the shortcomings of the existing legal system and the desire to create more responsive and accessible mechanism for justice delivery in the Mofussil areas. The dual system of government had proven defective and the courts were perceived more as instruments of power than dispensers of justice. To rectify this, a decentralized approach was adopted, leading to establishment of Diwan-e-Adalats as a means to address local issues promptly and efficiently. Diwan-Adalats was organized at the district level, reflecting the administrative subdivisions with the Mofussil regions. The administrative head of the district, often known as the Diwan, also served as the judge in these Adalats. The court structure involved a hierarchy, with appeals from Diwan Adalats being directed to the higher appellate bodies such as the Provincial Council and the Sardar Diwan Adalat in Calcutta. Diwan Adalats were vested with the authority to adjudicate civil cases covering a wide range of matters such as property disputes, inheritance issues, caste conflicts, marriage dispute, contractual disagreements and financial disputes. The courts applied Hindu law to Hindus and the laws applied Quran to the Muslims, demonstrating a nuanced approach to accommodate diverse religions and cultural practices. The Diwans were assisted by legal experts including Pandits and Qazis to ensure a thorough understanding and application of the respective religious laws. The establishment of Diwan-e-Adalat had a profound impact on the administration of justice in the Mofussil areas. It provided a more accessible forum for the resolution of local dispute, fostering a sense of justice and fairness within the communities. Now let us proceed and discuss the codification of civil law. Well, the legal landscape in India at the beginning of the 19th century was characterized by fluidity and uncertainty. Both the courts and the legal practitioners as well as the general populace grappled with the complexities of diverse legal forms. The prevailing English law, often relied upon, was itself marked by uncertainty and compounded by discrepancies between the legal system in the presidency towns and the Mofussil region. The need for more structured and uniform legal system became evident, leading to significant reforms initiated after the reformation of Parliament in the year 1832 and the subsequent passage of the Charter in the year 1833. Well, the Charter of 1833, a seminal piece of legislation driven by the efforts of James Mill and Mr. Macaulay, heralded a transformative phase in the legal history of India. Enacted on 28 August 1833, it came into effect on 22nd April 1834, fundamentally altering the structure and powers of the Government of India. Well, key provisions aimed at centralizing legislative power and creating more uniform legal system for the entire territory under the control of East India Company. The primary objective of the Charter of 1833 was to establish an all India legislature, appoint a law member in the Government of India and create a law commission for codification of law. This legislative council, created in the year 1833, marked a crucial shift towards centralization, granting authority to make laws and regulations for the entire territory under the control of the companies' governments in India. This was a significant departure from the previous emphasis on the decentralized governance. One of the pivotal aspects of Charter of Act 1833 was the provision of codification of laws in India. Well, the Governor Generals were empowered to appoint a law commission to study, collect and codify various laws and regulations prevalent in India. This marked a decisive step towards the codification of modern legal system, laying a groundwork for a more structured and accessible legal framework. The Law Commission appointed in the year 1835 was a key institutional development upon the Charter of the Act 1833. Operating under the direction and control of the Governor in Council, the Commission was tasked with initiating inquiries and submitting reports on the subject determined by the Governor General. Well, the Commission's primary role was to establish a comprehensive code of common laws to the whole of India, thus systematizing and classifying legal varieties prevalent in different regions. The first project undertaken by the Law Commission was the codification of penal laws for India, a monumental task that involved extensive collaboration and input. The Commission, under the guidance of Lord Macaulay, made substantial progress, particularly in preparing a draft for the penal code. However, the momentum slowed after Macaulay's retirement and subsequently initiatives were less remarkable. The Civil Procedure Code drafted by the first Law Commission was a comprehensive document that addressed various facets of civil litigation. Some key features included provisions related to the initiation of suits, to conduct the trials, the examination, cross-examinations, framing of issues and execution of decrees. The code aimed to streamline legal proceedings, enhance judicial efficiency and ensure a fair and accessible system of justice. The implementation of the Civil Procedure Code had a profound impact on the legal system in India. It brought about a standardized and structured approach to civil litigation, providing a clear framework for legal practitioners, judges and litigants. The code contributed the simplification of legal procedures, reduction of ambiguity and the promotion of more efficient and equitable administration of justice. Later, Sir Charles Wood made efforts in the direction of evolving a uniform procedure and directed the Second Law Commission to prepare a code of simple and uniform procedures applicable to all courts. The Commission had submitted 4 drafts of the Code of Procedure which were intended to apply the ordinary civil law lower provinces of Bengal and presidencies of Madras and Bombay and northwestern provinces. These 4 bills based on drafts were amalgamated to enact a uniform civil procedure code in 1859, which was applied to the Mofussil courts only. Well, after having discussion on the development of the civil law, we proceed towards our conclusion, and in summary, the evolution of civil law in British India within the Mofussil region represents a multifaceted and transformative phase in the historical narrative of colonial rule on the Indian subcontinent. The term Mofussil, referring to areas outside the metropolitan centers, captures the intricate blend of cultures, languages and traditions that defined these regions. The development of civil law in Mofussil areas was intricately shaped by a convergence of factors encompassing the challenges posed by cultural diversity, the imperative for localized governance and the directives of the British colonial administration. The Mofussil regions marked their diverse cultural fabric, posed distinctive challenges and opportunities in the evolution of civil law. The endeavours to harmonize customary practices with codified laws, cater to the specific needs of local communities and streamline legal procedures reflected the inherent complexities of administering just diverse territories. The enduring principles of justice, fairness and accessibility that persist in the contemporary Indian legal system bear testament to the lasting legacy of civil law development in the Mofussil areas. Well, the historical journey of civil law development in British India under the Mofussil region encapsulates a dynamic interplay of historical, cultural and administrative elements, from the uncertainties of the early colonial era to the transformative legal reforms of the 19th century. The progression of civil law exemplifies nuanced process involving adaptation, codification and localization. This historical trajectory laid down the foundation for the post-colonial legal system in India, underscoring the significance of governance tailored to specific contexts and the pursuit of justice within a diverse and dynamic societal framework. Thus, it is significant to acknowledge that the civil law under the Mofussil has laid the strong foundation for the development and evolution of civil procedure system in India. With this, we take a pause here for this particular module. Thank you very much.